Meeting. Hey, welcome to the joint hearing of House Human Services and House Judiciary Committee this Wednesday, January 15th. We're going to be digging into juvenile justice in the next couple days, and we're going to start with overview from our esteemed legislative council. They're both esteemed. Whoever's starting first, I guess Eric Fitzpatrick start first if you could join us. But before we do that, as you sit down, we're going to do introductions because a lot of new faces here. I am Art Malone and a representative from South Burlington and chair of the House Judiciary Committee. Which way should we go this way?
All right, thank you. My name is Teresa Wood. I'm from Waterbury. I also serve Bolton, Beals, Square, and Huntington, and I am chair of the House Human Services Committee.
Hi, Karen Dolan, representative from Essex Junction and sit on Judiciary.
Good morning, I'm Todd Nielsen, representative. I represent Brandon and Forestdale. I'm on Human Services.
Good morning, I'm Brenda Steady, Milton Westford, Human Services.
Good morning, Zach Harvey, Representative Castleton, and I'm on the Judiciary Committee.
Good morning, everyone. My name is Ian Goodnow. I'm one of the representatives from Brattleboro, and I'm on the Judiciary Committee.
Alicia Millay, representative from Pittsford, Judiciary.
Tom Oliver, Sheldon Swanton, Judiciary.
Okay, I guess you'll get. I didn't feel right skipping you.
We're team, so I get to go by.
Are we supposed to bow when you speak? I am the Honorable Angela Arsenault, representative from Williston.
Good morning, Dan Noyes, represent Wolcott, Hyde Park, Johnson, and Belvedere. I serve on the Human Services Committee.
Doug Bishop, Colchester, our Chittenden 20 district.
Good morning, I'm Zahn Eastis. I live in Guilford and I serve Guilford and Vernon, and I'm on Human Services.
I'm Esme Cole. I represent Hartford and I'm on Human Services.
Hi, good morning. Eric McGuire, represent Rutland City.
Good morning, everyone. I'm Ray Garofano. I live in Essex and I also represent Essex Junction and I'm on Human Services.
Online?
And online, Ken, introduce yourself.
He told me he didn't want to talk today.
Okay, all right. Well, in
Doesn't
that
want to
case,
say his
Ken
name.
Goslant from Northfield is online. He's in the Judiciary Committee.
And we may be joined by Representative Ann Donahue online as well. She's recovering from a broken leg.
Jeez.
Over to you, Eric.
Thank you, Chair Lalonde, and good morning. My name is Eric Fitzpatrick. I'm here on behalf of the Office of Legislative Counsel. As Chair Lalonde mentioned earlier, we're talking to you this morning about a number of issues related to juvenile proceedings, and I'm here with Ben Nowogorski as well. We've divvied up our presentation a little bit. In a sense, it's sort of, you can think of a timeline. I'm going to be talking about how it is that a young person who commits basically an act that would be a criminal act if they were an adult, how that person is treated in the juvenile system that we have in Vermont and how they get into that system. What happens to that young person once they get into the system is what Ben's going to cover. So if you think of that timeline, that sort of point, when they get into the system is when Ben's going to pick it up and I'm going to be talking about, well, how do they get into that system and where do they end up and what sort of factors go into play when that determination is made. So when I'm talking about that, if you think about it, the sort of big picture topic that this is about is what happens when a young person, a minor, a child, commits an act that undoubtedly would be a criminal act if the person were an adult, but they're not. So how does the legal system deal with that person from a criminal context? And if you think about it in that way, it's really one part of the law that treats young people differently in dozens and dozens and dozens of ways. I mean, you think about it. You think about voting or whether you can purchase and consume alcohol, whether you can serve in the military, or whether you can possess a firearm, or whether you can legally execute a contract. All of those things, the law treats a minor, a young person differently than they treat an adult, right? So this is just one feature of many, many ways that minors are treated differently. And this feature happens to be related to, well, what happens when that young person commits an act that would be criminal if they're an adult? So how does the law respond to that? Well, the main way, at least structurally, is that there's an entirely separate criminal justice system for young people, entirely different than the criminal division for adults. So you have the juvenile proceedings that occur in the family division of the Superior Court, right? On the one hand. On the other hand, for adults, you have criminal proceedings that occur in the criminal division of the Superior Court. They take place in separate courts, and they are subject to very different procedures. And that's sort of something that might be the first question that would pop into mind. Well, is there really a difference? Does it matter whether this young person goes into the criminal division as an adult or into the family division as a juvenile? And the answer is yes, it matters a lot, because there are significant differences between the way the two systems operate and the consequences that could befall a young person who's in the family division. And I'm not going to list all of those, but just a couple of the most important ones that often come to mind. For example, I mentioned consequences. If you're an adult in the criminal division and you have a conviction on your record, that is a public record for the rest of your life. That is always going to be there unless you went through some legal process, excuse me, like having your record expunged or something like that. That is an option, but that is not guaranteed by any stretch of the imagination. So you're going to have a record associated with your name for the rest of your life. If it's a criminal division, and if it's a felony, that could mean all kinds of other, what we often refer to as collateral consequences, right? You probably won't be able to possess a firearm for the rest of your life. Your international travel might be limited. Your ability to get a federal student loan will be limited. Your ability for federal housing. You might have to answer on a job application if they ask, did you have a criminal conviction? Yeah, an honest answer would be yes in that situation. On the other hand, if you're a juvenile, in the juvenile proceedings, those proceedings, if you successfully complete what your probation is, if what your caseworker has asked you to do, if you're successful in that, you don't have a criminal record when you come out. It's completely sealed. There's no effects that it would have on you for the rest of your life in the same way that a criminal conviction would have. You don't have to answer yes to that job application. So that's a huge difference. And as I was kind of alluding to, confidentiality, another huge difference. Criminal proceedings against adults are completely public. Any member of the public can go watch those unless it's been closed for some particular reason, but for the most part, they're not. The records are public. The names of the defendants involved are public. That's all public information. On the other hand, in the family division, juvenile proceedings, confidential. Not the person's name is confidential. They are not open to the public. They're closed. So that's another way, if you think about the consequences of whether it's a person's name ending up in the media or whether or not someone could just walk into a courtroom, for example, which you can do in a criminal courtroom and say, I wonder what's going on in there today. Can't do that in a juvenile proceeding. Closed. So there's an aspect of confidentiality that's extremely different between the two things. And you sort of think about, again, the consequences. So we've got confidentiality, the lifelong consequences in terms of collateral consequences, and the services that the juvenile gets are also different. So if you're a young person in the juvenile system, you're going to have a DCF caseworker, Department for Children and Families caseworker assigned to you. You're going to get services from DCF that aren't the same as what you'll get as an adult when you're under DOC supervision. Two different things. And you don't require to have a case plan for DOC the way you have to have a particular type of case plan if you're a young person. So the upshot of it is there a big difference between the two things? Yes. Many differences, many significant differences. And so what I'm trying to sort of lay out for you today before Ben gets into what happens when you get into these systems is, well, how do you end up in one of these places or the other? And actually, this is a good point to add in that in Vermont, we also have a third option. So I'm talking about, right now, so far, we've talked about juvenile proceedings in the family division, adult criminal proceedings in the criminal division. In Vermont, we have a third option, and that's what's known as youthful offender, sometimes called YO for short. Sometimes you'll hear people say YO treatment. They're talking about youthful offender treatment. And that is in some ways, it's sort of a halfway point between the criminal division and treating someone criminally as an adult and treating someone as a juvenile in the family division. It's sort of a mix of both things. And in fact, will indicate how long I've been here, but I remember when this was getting started and it was initially referred to as a blended sentence. It's because it's kind of a blend of the two things. And it's kind of an appropriate moment to remember Senator Sears, who's not with us today, but who was the initial person behind the youthful offender statute. I remember when it was getting started, and in the very beginning, it was very rarely used, and now it's become a really frequently used component of the juvenile justice system, and in large part because he had advocated for it for a long time. So the sort of quick nutshell of what that middle ground looks like, that youthful offender. Why is it a blended sentence? Why does it contain features of both? Is that the way it sort of operates is that it allows a young person who qualifies. So we'll get to it in a second of how does one qualify for these three different things. But if the young person qualifies, they are able to be treated in the family division as a juvenile. So they get all those features that I was talking about, the confidentiality, the DCF caseworker, the fact that it's not public. The confidentiality, there's a little bit of a difference there, a couple minor differences between the two proceedings, but for the most part, they get what you would get as if they were a juvenile in the family division. But if they don't comply, then they get sent back to the criminal division for sentencing. So you think of it, it's kind of like a carrot and stick, right? Because on the one hand, you have the incentive of, well, if you can successfully complete your juvenile probation, hey, you're going to come out without a criminal record. No one will ever know about it. Hopefully it'll remain confidential. You get all that positive. But if you don't, then you're going to end up back in the criminal division with a criminal conviction on your record, probably, and you're going to have all those collateral consequences. So that's why it's kind of a blend or a mix of both options. So we have those three tracks, if you will, available in Vermont. Criminal proceedings, treat the young person as an adult, juvenile proceedings in the family division, and the youthful offender sort of middle ground treatment. So now we get to the question of, all right, well, those are the three tracks. How do you end up in each one? How does that work? And so I would say that before we take a quick look, but I'm going to turn now to a handout that you'll see titled Big 11 offenses. And before we take a look at the language, I'll say one thing to keep in mind is that whether or not you end up in one place or the other of these things, generally speaking, turn on two factors. So keep these two factors in mind. What kind of offense was it? And how old was the young person? That's it. Those are your two kind of moving parts. And I wish it were as simple as, A or B. It's not quite that simple, but if you keep those two factors in mind, then you'll know that's how I'm going to end up in one category or the other. What type of offense was it? How old was the young person?
Eric, I just have a quick question. The first question is, how do you want to take questions? Do you want to wait till you're at the end, or do you want to pause at certain times? I just don't want, some witnesses like one thing, one way or the other.
Oh, well, thank you for checking. I'm happy to be interrupted. And
okay.
So whenever anybody wants to ask a question.
Okay. And just
them all the time.
Yeah. Gives me a chance to get it.
And just a reminder to people to be recognized by either of the chairs before you ask a question.
Thanks.
So, can I be recognized?
Yeah.
I know. So you were just talking about so how somebody gets to one of these, which procedure they get to.
Right.
What impact does plea bargaining have on that? So if it starts off as a higher offense and is bargained down to a lower offense, and maybe you're going to cover that. If you are, then I'll just wait for that answer.
I wasn't really going to touch on that, but it's a good point, especially in the criminal division.
Yeah.
That if a person does end up in the charged as an adult in the criminal division, plea bargaining can always come into play. That can always be whether that's at the front end, hey, here's what an option might be if you pled to this lesser offense, or maybe it could be during the course of the proceedings, a negotiation back and forth between the young person and the state's attorney.
Mm-hmm.
But yeah, that can always come into play in the criminal division for sure.
I'll touch on that too.
Okay.
Yeah.
Thank you.
So, so when we're thinking about, I said these two factors, right? What type of offense is it and how old the person is? So when we're talking about what type of offense it is, it's helpful to group them into two categories. And the two categories are on the one hand, big 14 offenses, so we're going to call it, at least temporarily, the big 14 offenses and everything else. And so those are your two categories, big 14, everything else. That's what this piece of paper is that I just passed out will start. So generally speaking, well, first of all, why is it 14? That's it may, for many people around this table, you may remember big 14, I thought it was big 12, right? And literally, I don't know, 6, 7, 8 months ago, it was big 12. Now it was only, and the big 12 is has been a legislative policy determination as to what offenses are so serious that they should start in the criminal division, right? Because generally speaking, with some age, subtleties that I'll mention in a moment, generally speaking, if it's one of these big 14 offenses, depending on the age of the kid, it's going to start in the criminal division, not in the family division. So what offenses get put on that list is up to you. That's a legislative policy determination as to what type of offenses should be the ones that start criminally, as opposed to a juvenile proceeding in the family division. And for decades, that list was 12 offenses, and it was known as the Big 12. This past session in Act 125, that Big 12 list got modified. 1 got taken away to 11, and 3 got added. So that's why it's now referring to it as the Big 14. But there's a slight difference between what you'll see on, if you look at the page, on the front page, it says Big 11. And if you turn around on the back of the page, it says Big 3. Add it up, Big 14. Well, why, you might think, why not just call it Big 14? Because there's a distinction between the 3, and the 3 on the back are the 3 that were just added this past year in Act 125. And on the front page, just real quick, go through them. What are the Big 11? Arson causing death, assault and robbery with a dangerous weapon, assault and robbery causing bodily injury, aggravated assault, murder, manslaughter, kidnapping, unlawful restraint, maiming, sexual assault, aggravated sexual assault of a child. So those are the 11. There's not a 12 at the bottom of that page, because that was the one that was struck this past year, and that was burglary into an occupied dwelling. So that used to be part of the Big 12 legislative policy determination that didn't really fit with the level that these other offenses are on. So that one's gone. That brought it to 11. In the same Act, 125, 3 more were added. Turn to the back of the page, the other side of the page. What 3 were added? Using a firearm while committing a felony, trafficking a regulated drug, and aggravated stalking. So why are there 3 on the back and 11 on the front, other than how many can fit on the piece of paper? It makes sense because the 11 on the front are going to the criminal division if the child is age 14 or older, right? 14 or older. Whereas the 3 on the back, it only applies if the child is 16 or older. So there's a distinction there. And that was part of the legislation that passed last year. They said, yes, the General Assembly agreed, we're going to add 3, but we're only going to have those 3 apply if the young person is 16 or older, as opposed to 14 or older. So that's how you end up with these Big 14 offenses, 11 for 14 and up, and 3 for 16. So when I said generally, these offenses start in the criminal division, the reason I'm saying generally, and this goes back to our youthful offender discussion, right? Because the state's attorney has another option at the time of filing. And option 1, which we just discussed, is, hey, the statute says these offenses start in the criminal division, right? If it's one of these, if it's 14, the first 11, or 16 up for the next 3, that goes to the criminal division, unless, there's a crucial unless. The state's attorney can decide to do what's called a direct file. That's a specific term. They can directly file the case in the family division if it's going to be a youthful offender case. Only that. They can't file it in the family division as a typical juvenile proceeding. But they can do a direct file, which is, we're going to file this, go right to the family division, but it's going to be youthful offender, remember? And that's that blended case, right? Because that sort of, they have that, if they go that route, that means if the young person doesn't comply with their probation, their DCF caseworker requirements, they get bumped right back to the criminal division for sentencing. So the state's attorney, if you think about it, has an extremely important decision to make at that point in time, because if that proceeding gets direct filed in the family division, it's confidentiality from the outset. From the time of filing, it's immediately closed to the public. The name of the offender is confidential. The type of proceeding that it is, all the features of confidentiality that attach to a juvenile proceeding attached to the direct file. But if they filed it in the criminal division, it's all public. So you see why that's a crucially important decision point at that moment for the state's attorney.
Representative Arsenault and then Representative Goodnow.
Eric, can you remind us, is that at the sole discretion of the state's attorney?
Yes.
So there's no conversation with the defendant?
Well, they certainly could. No, I mean, I should say by law, it's the discretion of the state's attorney. That
Yeah.
doesn't mean that conversation could take place.
Okay.
Yeah, and with law enforcement could be involved. It could be they could be in contact
Right.
with the court. It's
So they can
all
talk to
possible.
anyone they want to about it, but it's the final
It's their-
decision rests with the state's attorney of whether to direct file.
Correct.
Thank you.
Yep.
And, okay, because the big difference there being that if they don't direct file, but they have a sense that they'll ask to move to the family division,
Starts.
then the move to the family division almost eliminates all of the benefits and protections of being in the family division, for as far as like confidentiality is concerned. Like if they don't direct file as a youthful offender, then, and it's starting in the criminal division, even
public.
with the intent to move to the family division, it's already made public
Correct.
or publicly available.
Yes. And just to follow up on your point that, it's a nice segue, thank you, because there's two ways that you can get to the family division for youthful offender treatment. One is the one we're talking about, the direct file that we just mentioned, and the other is by motion in the criminal division. So if the case is in the criminal division, whether you thought of it beforehand as kind of, whether they were sort of long range planning it out that they were going to do that, or whether some factor came up later on that they're like, oh, you know what, this makes more sense for this to be a youthful offender case. Either way, the prosecutor, the defense, and the court, any one of them can file a motion and say, you know what, this looks like it ought to be a youthful offender proceeding. So we're going to request that decision be made, and just a moment of procedure on that. However you get to the family division for this youthful offender, whether it's direct file or because somebody filed a motion in the criminal division, what then happens is the family division has to make a decision about whether to keep that case as a youthful offender case. They have to, there's a risk assessment need screening that's done by DCF on the young person. DCF makes a recommendation to the family division, and the family division, and they have to hold a hearing, what I think is called the youthful offender consideration hearing. They have to have this hearing, and that is all confidential, or mostly confidential at least. And then the family division has to make a decision, and they can decide, we agree with whoever made the motion, or perhaps just based on the direct file, that this is an appropriate one to stay in the family division as youthful offender. But they can also, the family division can also say, for whatever reason, this doesn't look like an appropriate case for that, and they can send it back to the criminal division. But to your point, if it gets there after having been initially filed in the criminal division, that stuff that was public on the criminal side is public, and there's no changing that. It doesn't get confidential until it gets to the family division.
So you good? Before I get to Representative Goodnow, real quick. So the court has a check on the discretion of the state's attorney because they still have to accept it even when it's a direct file. I just want to make that clear.
Yes, absolutely.
All right. Representative Goodnow.
Thank you. This is an opportunity for me to ask a question that I've always sort of wondered. Why is the landing place for especially the Big 11 in the criminal court, given the age of 14 being when someone could potentially be charged in the criminal court, when the as we've already been sort of explained, the fact that it's going to be public and in potentially like in the newspaper and things like that. What's the rationale for not having all of these cases land in the family court first in confidential proceedings and then by motion move to the criminal court? Given the fact that I would assume that you're going to go through the same discovery, all the like, is there anything compromised in the case by having it originate in a confidential proceeding and then move to a criminal proceeding by motion on from a party?
Well, not to be evasive, but that's really your decision. That's the reason, is that it was a policy decision by the legislature many, many years ago as to long before I was here, that's the way the system was going to be set up. So it is a policy decision for you to sort of adjust or not as you see fit. based on maybe witness testimony as to what are the advantages and disadvantages of going in either direction.
Thank you. So, Representative Garofalo, Representative Bishop.
Thank you, Eric, for the information. Forgive my ignorance, but what you just talked about, is there data and who holds that data on how often this is happening across the state? And is it ever analyzed?
Yeah, I think DCF has good data on that. We've seen some of that before. So I think when you get your witnesses.
DCF holds
Yeah, and the court might also as well, now that I think of it, they both could have the numbers of cases, for example, that get filed as juvenile, the number of cases that go on offender, and the number of resolutions that happen on each. So I think you'll be able to get some good facts on that.
To follow up on Chair Lalonde's question to make sure I have this correct, the family court's screening and decision as to whether to keep a case as a youthful offender case is in both instances of when there is a motion and when it's direct filed, or just when there's a motion?
Actually, both.
Both.
Yep.
Okay,
Yep.
thank you.
Yeah, they have to have that youthful offender consideration hearing, and then there's a pretty detailed statutory process about what has to be in the what criteria the court considers, what the public safety standard that the court has to consider when it's making that decision. It's a very, like I said, detailed process about what goes into the court's decision, and the fact that they have to make it in either case.
Representative Harvard.
So a question on the Big 14. How does that compare to other states? Is Vermont unique in the 14 that we have? Is it comparable to other states?
That's a good question. I don't know the answer to that at the top of my head.
I'd be
But
curious to
that is
see
something
that.
we can look into, right?
And I also have a follow-up on that. Since burglary into a dwelling has been removed from the Big 14, has the state of Vermont seen an increase in
That's
those crimes?
right. That would be another data question for
Yeah.
the court, for example.
Yeah.
Yeah.
Thank you.
Yeah, sure. All right, shall we move on to?
Please.
All right, so remember I said there's two factors that go into, right? Where one of these case ends up and what type of offense it is and how old the kid is, right? And we just talked about sort of what type of offense it is. So we kind of went through that element of the two factors, and that's whether it's a Big 14 or not. So let's turn to the other factor, which is age. So like we said, generally speaking, if it's a Big 14 offense, depending on whether it's 14 and up and 16 or up, that's going to start in the criminal division, right? If it falls into that other category, which was everything else, right? Which means all misdemeanors and felonies that aren't on this list. So if it's any one of those everything else offenses and the child is 18 years of age or younger, starts in the family division, right? That's where it begins. And you'll notice I said 18 years of age or younger, right? That also is a relatively recent development because for the history of juvenile proceedings in the family court or the family division, that age had always been 17 or younger, right? And this sort of nicely segues us into the other topic I wanted to cover, which I think the committee wants to talk about during the course of these proceedings as well, which is the Raise the Age initiative that the legislature has been engaging in for 7 years now. It started in 2018 that the legislature has been working on this. And what that means is, as I said, right now, if it's someone who commits one of these non-Big 14 offenses and they're 18 years of age or younger, starts in the family division. Up until 2020, it was 17 years of age or younger. And that's when the legislature had been working on this for a couple of years and made the decision to institute and implement a Raise the Age change to juvenile proceedings. And that is, if you think about it, it's raising the top age, raising the maximum age at which a person can be treated as a juvenile in the family division. It started by going up from 17 to 18. And that's when it happened, as I mentioned, July 1st, 2020. Now, what that meant was, prior to that time, if you were age 18, for example, and you committed some offense that's not on this list, say you were shoplifting or you stole a six-pack of beer or something like that, when you were 18, that would have gone into the criminal division as an adult before July 1st, 2020. Since that time, now that same offense, age 18, goes into the family division, right? So that's step one of Raise the Age. It's in effect. It's been in effect it'll be going on 5 years this coming year. Step two, which was also in the original enacting legislation, was to bump it up one more year. So it wouldn't just be 18-year-olds, it would be 19-year-olds who committed again. It's not the serious big 14 offense. It's some other, one of the other offenses. You commit one of those and you're 19, you start in the family division again. Now, the implementation of step 2, which is the increase to raise the age one more year to age 19, was originally supposed to go into effect 2022. So it gave it 2 more years, 2022. For a variety of reasons, this has been this implementation date, excuse me, has been postponed 3 times now, I believe it is. So originally, and that's I say for a variety of reasons. One of them was COVID related. There have been issues related to staffing, resources, to preparedness, to all kinds of different factors that the legislature has taken into consideration when it's made this decision 3 times now over the years to push it out. So it got pushed out the first time from 2022 to 2023, second time to 2024, and then just last year in the same bill that I've been referring to, Act 125, it got pushed out to somewhat unusually, usually when an effective date is July 1st. It's actually April 1st. So April 1st of this year, 2025, the way the law is written now, these 19-year-olds who commit non-Big 14 offenses will start in the family division. So that means, it's an important factor for you all to think about, is that if you do nothing, you take no action on that implementation date of the law, it will go into effect on April 1st. So, because it's already set up now. So it's good for you to know that what are the effects of your decision to take action or not take action. So that one is scheduled to be implemented in a few months. So that's where the raise the age status stands, and sort of segues us into, as I said, the general rule of thumb is Big 14 offense starts in criminal division, depending on whether it's a 14 or 16-year-old. Non-Big 14 offense starts in family division. There's often an opportunity to transfer between divisions, though, and that's why we don't necessarily have to go through it all right now. But this other chart that I put together, I also handed out, will give you sort of a handy-dandy way to look at it and say, oh, where does that age start again? What offense was it? So you can hopefully be able to take a peek at this chart, and we'll kind of track you to where that starts. And we'll, for example, just to look at the first 2 rows, kind of remind us of what we just talked about. Hopefully, it won't contradict anything I just said. But actually, I should say, when you see the contradiction, point it out. I'll fix it. But so the first column, for example, this is the Big 14 we talked about. Separated into the 14 to 21s, the Big 11, the 16 to 21s, Big 3 adds up to 14. The age, offense, where does the case begin? Begins in the criminal division. Below that, you see we mentioned the direct filing begins in the criminal division unless the state's attorney direct files it, right? And actually, so jump over, if you don't, to the last column there. Is youthful offender available? Yes, 2 ways, via direct file, which we just talked about in the family division, or the transfer from the criminal division to the family division that we also talked about. So there's those 2 ways it can get to the family division, is youthful offender, direct file or transfer. And you can see that it just sort of mentions that you have to have this consideration hearing and the family division has to approve. Back for a second to the third column, then transfer. Yes, so there's oftentimes, not always, but oftentimes ability to transfer between divisions. You see there's 2, for example, for these Big 14 offenses. First one we just mentioned, it can be transferred to the family division if there's going to be youthful offender treatment. But also there's an interesting feature for 14 to 17-year-olds only who've committed one of these Big 14 offenses. There is an ability in statute for the court to just transfer it to the family division for delinquency proceedings, for juvenile offender treatment. It's an interesting statute in that there is no statutory language about what factors the court ought to consider in that sort of situation. What are the criteria that go into that decision? The kind of things that I mentioned that are involved, for example, in the youthful offender hearing, there isn't any of that. It's just a relatively straightforward statement that for that age, family division can transfer for delinquency proceedings. It also contrasts, you'll see down below, so bump down 1 column. This goes to the other group, right? Non-Big 14 offenses, age 10 to 18. I also put a little note in there on April 1st, bumps up to 19, but go over to the next column. Where does that case begin? Family division, right? Under 10 to 18, non-Big 14 starts in the family division. Third column, is transfer available for those young people? So in other words, you start in the family division for a misdemeanor or for one of those felonies that's not part of the big 14. Hey, can that case ever get transferred to the criminal division, or is it locked into the family division permanently? Often a question that comes up. Answer is, look at it, misdemeanors, no transfer for misdemeanors. Those stay in the family division. But for felonies that are not on that big 14 list, there is an opportunity to transfer for 16 to 18-year-olds. So again, that one's going to go up to 19 as well with the raise the age if that stayed in effect. But for that age group, there is an opportunity for a motion to be filed and to have that offense, even though it's not a big 14, but it's some other felony. And if the person is at least 16, have that transferred up to the criminal division. And in that case, there is a detailed statutory process that's involved. There's the requirement of the motion, the requirement of a hearing, specific findings that a court has to make. There's detailed criteria for what goes into the transfer decision. So for the transfer up, sometimes they're referred to as a transfer up or a transfer down. For the transfer up, there's, like I said, a lot of statutory language about what has to go into that decision. But for the transfer down for 14 to 17-year-olds, for whatever reason, I wasn't here when that happened, but there isn't a similar level of sort of, instruction about what's going to go into the court's decision about whether or not to make that decision. So that covers really those first two columns. What I mentioned, that there's a few other sort of that don't quite fit into those two categories that I've listed for the last three. For example, we talked about how, generally speaking, for the big 14, they start the criminal division for 14 and up or 16 and up. There's another feature. This is number 3 on your column, 12 and 13-year-olds. So they're younger than 14, right? Ordinarily, you think, 12 and 13-year-olds, they start in family division, right? And that's true. Look at the next column. It does start in the family division if it's a big 11 offense. But similar to what we just talked about for the 16 through 18-year-olds, there's an opportunity for transfer up. So if it's a 12 or 13-year-old who commits one of those big 11 offenses, they start in the family division like the other 12 and 13-year-olds. But if they've committed one of those big 11 offenses, can file the motion for transfer. They have the same kind of criteria that the court has to consider. So the court can send that one up to the criminal division as well. That also has this interesting feature that brings to light another topic that you will sometimes hear discussed, and that's in the last column for those 12 and 13-year-olds, is youthful offender available. Yes, but remember, the only way to get into the family division for youthful offender is for a direct file or for a transfer from the criminal division. So if you're starting in the family division like you are with these 12 and 13-year-olds, in order to get to the family division, in order to get there for youthful offender treatment, you have to transfer it up to the criminal division first, file your motion there to transfer for youthful offender, have it transferred back down to the family division where you started. That's often referred to as the ping pong effect.
Didn't we try to fix that?
We did, fix is a strong word. But I was going to say ameliorated, made it better. Yes, I think that there was a lot of discussion between the different stakeholders involved in this about fixing it. Turns out to seem like it would be simpler than it is. The improvement that the legislature made was you allowed the parties to stipulate. So if the parties agree, hey, this really should be a youthful offender case, we can go right there. We don't have to go up to the criminal division and make a motion and come back. So it's hopefully, if I remember correctly, the idea was to at least take those cases where there isn't a dispute and have those skip that, redundant court process.
Yeah, that was 2 years ago, so I'd forgotten that already. But Representative Nolan?
Yeah, thank you, Eric, for providing this overview in this chart. I feel like you do it for us every year, and I'm like, oh yeah, I just barely get it a little bit. And for me, I just want to offer for others is having this chart is great, but a takeaway is that there's lots of different on and off ramps to get to these different places. And I think for us as legislators, the goal is why do we want the youth, whatever, in the juvenile or the criminal, and really understanding what's the difference between a criminal and family division and I don't know if that's what Ben is going to talk about, but I think to really highlight some of those differences of what the experience is in the criminal versus what is the experience in family, so that as we see this, that's the piece that we're trying to look at. So for me, I just know there's lots of different on and off ramps for it, but where do we want the person to be? What is the goal that we're getting out of it?
Yeah, I think that's exactly what Ben's going to be getting into. Yeah, sure. Yep. And that almost segues right to Ben. Just the last two little things on the chart, you'll see it just because they're also slight outliers. Well, the last one's not an outlier, but you have an under 10 unusual situation that's in Vermont law that's for murder specifically. Now, remember, if you look for cases that start in the family division, that's number 2 on your chart. Remember, it's generally age 10 to 18, right? If you committed a non-Big 14 offense. So the family division has jurisdiction over children starting at the age of 10. So if it's below age 10 and you commit some offense, that's not a juvenile offense. So that could be something that could come up in a DCF proceeding, a child in need of care supervision proceeding, could be, some sort of parental rights termination proceeding. That could all come up that where the person behaved, but does not subject the young person to juvenile proceedings if you're below age 10. The one exception, Vermont statute specifically provides that even for an under 10-year-old, if murder is the alleged offense, then that person could end up, can be charged in the family division in a juvenile proceeding. So it's just good to know that all these different moving parts are out there. And lastly, the very bottom, above age 18, that's age 19 to 21. So non-Big 14, misdemeanor or other felony. Again, those are treated similarly to the other family division cases in the sense that they can be transferred, although they start in the criminal division because they're above age 18. There's still the opportunity to either direct file that case and then as a youthful offender in the family division, or file a motion in the criminal division and have it sent down. And that's in part because the age range for youthful offender is higher than for juvenile cases. That goes to the person being age 21. So those cases can go back down even though the person is over age 18.
Any final questions for Eric? I don't see it.
Thanks,
All right.
Eric.
Yeah, thank you very much.
You bet. Thank you. Any other questions? Let me know. Sure.
I have a computer, so you're gonna bear with me as I get set up. But I feel like Eric's answered all your questions, so I'll just. Just bear with me a minute. Of course, my computer's not. So you'll notice that this is a 20-page document. It's really aimed to be a reference tool for all of you to go back to as we all learn about this together. I'm gonna try and connect to Zoom meeting.
For folks with electronic devices, you can also find it on your committee's webpage.
Yes. So to start, my name is Ben Novogrodsky. I'm from the Office of Legislative Counsel. I am another member of the Judiciary team with Eric. I also deal with correctional issues. This does kind of blend that a little bit. I know that there were a lot of questions about data and where to access it. The Department of Corrections has robust data collection capabilities, and the courts actually rely on a lot of their data collection. So that's another resource for all of you to go pursue. And many members of the Judiciary Committee are familiar with the DF data. So I just wanted to put that out there as well prior to getting started. But now that I'm logged on, I will share my screen if I am a co-host and allowed. Look at that. You're on it, man.
There you go.
So we are going to present the slideshow. All right. Get that. Okay, so juvenile judicial proceedings. Eric did a great job at elaborating how you get into family court or criminal court. And I'm going to talk about what happens once you're in family court. I'll do a brief overview, sort of refreshing everyone on what Eric just talked about. But first, there are some terms that are really key to know. The first is, what is the definition of a child? And that includes an individual who's alleged to have committed an act of delinquency after becoming 10, but prior to becoming 22 years of age, unless it's otherwise provided in chapters 52 or 52A of Title 33, which are the juvenile justice chapters. And as Eric talked about, there are many differences in laws that do affect how it is, but that's sort of the starting presumption. Then there's the court, which is the family division of the Superior Court. So that is the home of these cases. And a delinquent act is one that's designated as a crime under the laws of this state, another state, or the federal government. But we refer to it as a delinquent act or delinquency in family court. It's not a criminal act, because then it would be in the criminal division. A party, there are lots of parties to family court cases. The child, the state's attorney, the commissioner of DCF, the commissioner of corrections in youthful offender cases, and other persons who are proper and necessary to the proceedings, which would be a decision that's made by the court if someone moves to be included for party status. And then there's probation. Probation is a big factor in these juvenile justice cases. And this is a legal status created by order of the court involving a violation of law where a delinquent child is subject to the supervision of DCF. And that's a key distinction between the family court and criminal court. Family court, DCF are your supervisors. Criminal court, if there's anything that happens, you're either supervised by the Department of Corrections or on your own. And so there are conditions that are specified by the courts that are memorialized in the juvenile probation certificate, and that's subject to return and a change of legal status by the court if you violate those conditions. And I'll get into that later on in the presentation about what that looks like. And then there's the term youth, and that's an individual who's subject to a motion for youthful offender status or has already been granted youthful offender status. And then finally, youthful offender. And that's a status that allows for older youth with more serious offenses a path to avoid criminal sentencing by addressing the offense in family court.
Representative Arsenault and then Representative Harvey.
Ben, can you, thank you, Chair, can you just briefly describe the importance of being a party to a case?
I mean, if you're a party to the case, you are part of the case. You know, and you also are privy to information since these are confidential proceedings. If you're not a party, you're a member of the public, and therefore you don't have a right to information unless you're a victim. And then there are certain limited exceptions where you can access information about like who is the subject of it and some sort of corollary adjacent issues, but it's not like open court like it is in a criminal case.
And so the fact that there are a number of established parties in juvenile proceedings, to Karen's point about some of the differences between, some of the really important differences between criminal proceedings and juvenile proceedings. Yes. This, you know, DCF and things like, they're not going to be a party in a criminal proceeding.
Correct.
So I just wanted to like really draw that point out that in a juvenile proceeding, there are a number of additional interested parties with party status, which really, I think, impacts the course of the proceedings.
Yeah, exactly. Because in a criminal case, there are traditionally only two parties, the state and the defendant. And so you can tell here that it's a lot more of a collaborative environment, if you will, in family court. And from a personal anecdote, I used to be in private practice and I had a single youthful offender case. And that was a sense that I got when I was in court, is that everybody understood that there was a certain objective that they were trying to achieve, which is different objectives than you're achieving in criminal court. So I think that's a good segue to say, what are those objectives?
Before you go, Representative Harvey has a question first.
Thank you, Chair. Ben, if you go back to the last slide, please. I'm just trying to understand, are the terms child, and should I be thinking of the terms child and youth as synonymous with one another?
No.
So what exactly would I call, say, an adult man or woman who's 19 years old that's committed a crime?
Well, it depends where they are in the court system. So if they're in criminal
That's
court,
not a child, right?
well, they could be depending if they're in family court. But if
A
they're
19-year-old or a
Mhm.
20-year-old that's committed a crime?
Yeah.
Okay.
But if they're under youthful offender status, they would be a youth or youthful offender. But if they're in criminal court, you could just refer to them as an adult.
Okay, thank you.
It is confusing.
Yeah,
Just
Representative
steady. Oops, sorry.
I have a question, only because I know a lot of kids. Because I've been so involved with kids all their lives. I found a child once that went to court diversion when he did like a non-big. He didn't even get to the court. He did a court diversion.
Yeah.
So how do they determine the court diversion to get to the non-big 14?
Well, there's a process for it, and I'll get to that.
Okay, so you're coming to that.
Yeah, exactly. But let's talk about what the objectives of juvenile justice are. And the state has a policy that essentially it's about public safety, connecting youth and young adults to age-appropriate services to reduce their risk of reoffense, and when appropriate, to shield them from the adverse impact of having a criminal record. So that's the state policy when it comes to the juvenile justice system. And beyond that, the system is data-driven and tries to employ evidence-based practices to the extent that it can, offer those broad range of alternatives like diversion, such that when the court does intervene, it's commensurate with the risk to reoffend. So you don't want a heavy hand for a low-level crime. It's really trying to find that sweet spot, so to speak, for rehabilitation, getting kids to become productive members of the community, but maybe giving them that carrot that they need to do that. And you'll see that the purpose is to remove children from committing criminal acts, that taint of criminality that can follow them through their whole lives, and the consequences of that criminal behavior, so that they can get the supervision, care, and rehabilitation to ensure balanced attention to protect the community, accountability to victims and communities for the offense that were committed, and to develop their competencies to enable them to become responsible and productive members of society. So that is really, in a nutshell or on a page, the goals of the juvenile justice system and why it's different than the criminal system.
And just to clarify, that comes from statute.
Yes.
I think it's 51, section 5101, if I'm not mistaken. Just that's where that originates from. Yeah, Representative Dolan.
Yes, thank you for sharing kind of the goals of juvenile justice, and you shared how it's different from criminal I don't know if it's fair for me to ask, or if you can ask to just kind of make those distinctions of how is this different from the goals of criminal justice?
Well, I think if you ask different people what the goals of the criminal justice system, you'll get different answers. There's, some of it can be considered punitive. It can be considered rehabilitative. It can be considered the goal to prevent recidivism. But it's a lot, the care and the rehabilitation part, I would say, is not as explicit. So ultimately, if you commit a crime, you're going to have collateral consequences affecting your ability to possess firearms, potentially your ability to vote, ability to obtain housing assistance. There's a whole list of things that if you are convicted of a criminal offense, that really can affect your livelihood. That's not present here. And also incarceration. There's not incarceration in the traditional sense in the juvenile system like there is in the criminal system. But there is secure housing and detention, which I will talk about. But it's, again, a different objective.
It seems like it's fair to say, Ben, that given what Representative Malone just referred to, that it's more explicit. The goals of the juvenile system are more explicit in state statute than the sort of a little bit meandering goals of the broader criminal justice system.
Yes, I think that's fair. Any other questions before I move on? So just going over sort of briefly what Eric just went over, but how do you get into the box of juvenile jurisdiction? And the family division generally has that exclusive jurisdiction over all delinquency proceedings. The The court's jurisdiction and any DCF supervision starts at 10 and generally does not extend beyond the child's 18th birthday. However, there are certain circumstances where it can be extended. So if a child was 16 or 17 years old at the time of their offense, supervision can be extended to 19 and a half and can also be extended to 20 and a half if they were 18 at the time of the offense. So but there's a motion that's made to do that and there's a whole process, but it's good to know that they can be extended in those circumstances. And jurisdiction over youthful offenders cannot extend beyond the youth's 22nd birthday. That's essentially a hard stop. And as I was saying before, they're generally confidential, unlike in criminal court, which everything is open to the public unless the judge issues a gag order or something to that effect. So this is a list of essentially what the delinquency procedure is and all the different touch points. There's a law enforcement encounter, emergency care order, temporary care hearing. Those are essentially if someone needs to be detained for a bunch of reasons, you go through this process. There's the filing of the delinquency petition, which is essentially the charging instrument, the indictment or the information in a criminal case. There's a preliminary hearing, which is like the arraignment in a criminal case, that risk and need screening that we mentioned, a pretrial hearing, a merits hearing, which is the trial. Then there's a disposition case plan that is essentially developed and potentially adopted by the court. There's a disposition hearing, which you can think of as the sentencing hearing. And then there's the order, which could order probation, or there's a series of alternatives that the court can order for the child or youthful offender to follow. So that's just a brief overview, and I'll get into each one of these in the presentation. Any questions on the general procedure? So law enforcement encounter. There are two ways that you can be essentially if you're going to be arrested or cited. Those are the two forms. So let's talk about citation by a police officer. That's when an officer has probable cause to believe that a delinquent act occurred and circumstances don't require them being taken into custody. Probable cause essentially means that there's sufficient evidence of criminality. So that can be done through observation, that can be done through reports. But basically, you can be cited. You'll get a piece of paper from the police officer to show up at a certain day and time in the family court if this situation occurs. And like I said, there's that the officer hands the paper to the child, will also send it to their guardian or adult, and the child is released. And the citation and the officer's probable cause affidavit, for those of you that aren't as familiar with the criminal justice system, in every filing for an information like this, there has to be an affidavit of probable cause. So that probable cause that I talked about, the officer has to document it, has to sign it under the pains and penalties of perjury, and it has to accompany in this case, the citation or the citation in a criminal court. So that is the supporting document of probable cause. And then there's custody. So what happens when a child is apprehended? So they can be arrested or taken into custody if the circumstances warrant it. The custodial parent or their guardian is immediately notified when this happens, and the child is supposed to be released to them unless there's an issue concerning the child's immediate welfare, protection of the community, or both, which would require removal from the home. So you'll hear a lot of that terminology, removal from the home or home life or whatever, and that's sort of the foundation of this, is that you're still caring for children in the eyes of this system, right? And a lot of times there may be criminality that's a result of maybe a difficult home life. And so these are factors that are also considered in this process as well. So I just want you all to keep that in mind as we progress through it. And then a child can only remain in custody if there's an issuance of emergency care order. So what is that? An emergency care order is essentially a process to transfer temporary custody of the child from their home to DCF pending a temporary care hearing. So think of this as, okay, we've arrested a child. That's a really serious thing. We need to get going very fast to issue an order to say, okay, there are these reasons that they were held on an emergency basis. And then to continue to hold them, they have to go to this temporary care hearing, which is a fuller evidentiary hearing where they can present evidence to support the reasons that they gave in the emergency care context.
And
Go ahead, Representative Carson.
when you're saying they, you're talking about DCF, the burden to sort of prove that this child should be held is on.
The state. So it would be the state's attorney, but can also be supplemented through that officer's affidavit and DCF if they're aware of the case ahead of time. So the way it goes, the state's attorney immediately files that request, or if you don't do that, you have to return the child to home immediately. If the child is taken into custody after hours or on the weekend or a holiday, the state's attorney must contact the judge. So phone call, to request that emergency care order. And then that supporting affidavit has to be filed the next business day. So you don't have time to waste. And again, that is
Representative Cole.
Thank you. I'm wondering if there are legal definitions of the term home, just because it's so different for different.
well, so I paraphrased this, but it would be the child's residence, I think. Yeah.
Okay, and that, I mean, I imagine, yeah, residence is in flux for some folks who have like.
Well, I think if you talk to the practitioners, they would talk about how sometimes where there are, unhoused children.
Yeah.
That's a factor that might go into some of these decisions.
Yeah.
So maybe maybe family and in the loosest sense of that term, because it could be your biological family, but it could also be a relative or a friend with a vested interest in the child. And we'll kind of touch on that generally later on.
Yeah, Representative Steady.
To piggyback, if they're living in cots, if they're living in hotels, is it with family, not just home? Because a lot of these families that do have children, and I don't want to stereotype, are living in cots, are living in hotels. So wouldn't it be easier to stay with family instead of home? Because a lot of them don't have homes.
I mean, that would be a policy decision, I would say.
I
But
think that would be a.
family also has its own, I think, issues as far as what people generally view as family compared to what other people may view of it. So, and my battery is dying somehow already. So if you,
While you're hooking up, I'm going to ask you a question.
yeah,
So, and maybe you'll go into this. If you are, then, just disregard, but, yeah, in the past, we've heard that DCF has a fair amount of influence. I guess that's the word I want to use over, over this process in terms of their recommendations, their ability to secure the kind of placement that somebody might think is needed. I know in the past that, for instance, folks, this is going back a few years now, though, when we had Woodside, that, AHS essentially in this process had the ability to influence who actually came into, I'm not sure if it's called custody or not at this point in stage, but, and whether they were in a secure placement or not. So I guess I'm just asking whether that's true or not.
I mean, I would say it depends on the case, to be quite honest. But, especially if they are aware of a situation ahead of time and then it results in taking a child into custody, the information that they provide and can supplement in an affidavit was probably of value to the court and will inform the decision. So if they make a specific recommendation, it's probably reasonable for the court to at least consider it. And then ultimately what they do is up to them.
Yeah.
Well,
Representative Steady.
they don't have Woodside anymore, but they have Brattleboro Retreat where the police can send them there.
Yeah. We'll be hearing from DCF a little bit later, so we'll hear about their
I
options.
know it's weird when you work there.
Again, Apologies for the technical issues. I'm a little out of practice. But so we were at the emergency care order. So what occurs is if the state's attorney immediately files that request or directs the immediate return of the child. If the child is taken into custody after hours, blah, 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 then the law enforcement affidavit is required, and that can be supplemented by DCF. So that's what I was talking about. If it has knowledge of the situation, they may provide an affidavit providing further context, if you will.
I can ask a question.
Yeah, if somebody can let me into the meeting.
Do you have?
No,
Oh, can you talk a little bit about notice to guardians and how that, maybe this is a question for the folks delivering that notice, but I'm wondering how much, let's say how if it's difficult to contact the guardian, is the child just being held until there is notice, or do they have to be released after a certain amount of time if notice is if they're not able to provide notice?
I think that would be a good question for the practitioners, but they're required to give notice to their parent, guardian, or custodian. So I'm not quite sure what would happen if they can't find them. But I would ask the practitioners. So I'm gonna go, if you bear with me, just fast forward through citation. Care order, we talked about all this, all that, and we're now talking about an ex parte. So this is if the circumstances warrant it, where maybe there's a dangerous situation for the child or something like that. This can all be done ex parte. So that means without the child or their parents knowing, where this process would be done. They don't have to be notified of it in that instance. And then there would be a notice after the fact, but maybe there's a dangerous situation at home. And so if you don't want to notify the parent that this is occurring. So that's why there's this ability to do that. And then there's the issuance of the order itself, or it can be a conditional custody order. And conditional custody can say, okay, well, we're going to release the child from our custody back to the parent, but there are going to be some terms and conditions that you need to follow in order to retain custody. Or they could transfer custody to, say, a relative with certain terms and conditions, or retain custody within DCF along the same lines. So there would have to be probable cause that the child committed that delinquent act. So this is that's essentially, think of it as almost an arraignment where you're showing that there was criminality. Then you need to show that the continued residence in the child's home or living situation, whatever it may be, is contrary to the child's welfare. And the notice of that order is sent to the custodial parents, guardians, or custodian and other parties, and there are reasonable efforts to supply it to non-custodial parents, but no requirements, if you will. Any questions on that procedure before we get to the temporary care hearing, which is the next stage of this process? Okay, so the temporary care hearing is the evidentiary hearing, really outlining the next step of the emergency care order. The presumption is that the child would be returned home unless it's found by preponderance of the evidence. Remember what preponderance of the evidence means? Come on, Judiciary Committee, I'm looking at you. All right, it's more likely than not. So like,
And I'm not even on Judiciary.
there you go. Get the gold star for the day. So more likely than not, that such a return is contrary to the welfare of the child. And there are a list of factors that go into that. They can't be controlled at home and present a risk of harm to themselves or others. Continued residence in the home will not protect the community because of a serious and dangerous nature of the act the child is alleged to have committed. And you'll notice that's very specific wording. Not because of the nature and act of the child, or of the child themselves, but of the act that they committed. So, you know, this, I think, is language that speaks to, again, the goals of the juvenile justice system, which is they're still forming. We don't really know what they're about yet, but the act that they committed has these indicators. And then the child's welfare is otherwise endangered, which gives a lot of discretion to the court to make that determination. It must be held within 3 days of that emergency care order. So we're getting to this quickly because they're kids. The state files a petition on or before the temporary care hearing. So that would be the delinquency petition, which I'll get to, which is essentially the information. So the reason why you do that is that why are we going to hold these people if there's not going to be a case anyway? So let's make sure that the petition is filed. And if there's no petition, all orders are vacated, the child is released, and it's as if nothing happened. Except it did, but. And then the temporary care order itself, this goes into what I was talking about before. They can have conditional custody, returning the child home with conditions. There's a 6-month presumptive duration of that order, but that can be revisited and extended. Transfers to custody a non-custodial parent or relative, again, sort of that 6-month time frame, which again can be extended. And then transfers temporary custody to DCF. And then the initial case plan, which I'll get to, must be filed within 60 days from the home removal, because if DCF is going to retain custody of this child, then you need to make sure that their case plan, the rehabilitation, whatever the goals are, is being done in due course.
So I think this is a good time to get a little breather. So we're going to take a 10-minute break and